Hey, Mark Dawes here, and listen, this is just another video, and I'm doing this video on the back of the other two videos I put out about rigid cuffs and also about patients that self-harm, because I've had a question come in. It's a really interesting one, and this is from someone who's very concerned. They're concerned because they're being told that they can't use certain techniques, but they feel they need to use certain techniques, and in effect they've done a risk assessment that highlights they need to use certain techniques, and if they don't use these techniques, then the risk of harm isn't going to increase, and they're quite concerned that someone could actually die. So this is quite serious. Now, what they're telling me is that they're being told they can't use these certain techniques because if they use them, it's breaking the law. It's not in line with the company's guidance and the company's policy, and their accreditation and their approval will be revoked, or they won't get it or something if they use these techniques. So what I thought I'd do is I'm just going to show you a hierarchy of stuff that I teach when I'm actually running courses. Now, I'm not a lawyer, I don't profess for this to be legally accurate. It's purely a framework model to help people put things into context and into place when they're talking about guidance and the law and policy and procedure. So if you'll allow me, let me show you what I'm talking about here. So let's say here we have common law and acts of parliament, and there's loads of acts of parliament out there. You could have the Mental Health Act, you could have the Children's Act, Housing Act, you could have the Mental Capacity Act, Mental Health Units Use of Force Act that's come out, and obviously Section 3 of the Criminal Law Act. Now, common law and acts of parliament give us our rights, our legal rights, and our restrictions on what we can and can't do. And these are primary pieces of legislation. So anything with the word act after it, apart from common law, of course, is statutory law, and that tells us what we can and can't do legally. Now, underneath these things, you'll have regulations. Now, regulations are interesting because they're the strongest form of official advice that employees have to follow, and they are legally enforceable. And they're made by government ministers, and if you take the Health and Safety at Work Act, for example, the line above, you would have various regulations underneath that, like the Manual Health and Safety at Work regulations, the manual handling regulations that you would need to follow. So, that's legally enforceable. Underneath that, you'd have ACOPs and statutory guidance. Now, ACOP is an approved code of practice, and statutory guidance is stuff with special or specific, if you like, legal standing. Now, they deal with a wide range of hazardous materials and working practices, and employers who are prosecuted for a breach of health and safety law who have not followed an approved code of practice or have not followed statutory guidance, which is something issued by a minister, for example, under one of the acts or other acts that are above as examples, the court will actually want to know why you didn't follow it. Underneath this, though, we have non-statutory guidance, and an example of that is NICE guidance. NICE guidance is non-statutory guidance. So it's there to help and assist us to provide best working practice, but it's not legally enforceable, and you can detract from it if need be. And then below that, you'd have local policy and procedure, which is normally written by local managers or someone locally within an organisation. So the last two have no legal standing whatsoever. Above common law and acts of parliament, though, you have the Health and Safety at Work Act, and this is really interesting because let's say, for example, you are a housing officer, and I've dealt with this, and you work for a local authority, and your local authority says, we want you to go into a specific area where we have housing stock, and we want you to check, that the housing stock's okay, check electricity, water, whatever housing officers do. But there's a risk of being assaulted and seriously injured. And in the case that I was involved with, they actually had housing officers who were being attacked with dogs, staves, they had petrol bombs even thrown at them, and it was not safe for them to go in. But the local authority said they had to go in under the Housing Act. But the Health and Safety at Work Act says, look, you've got to make sure that your work environment is safe. So this in a way overrides this, where you can't just rely on the law and regulations. You've got to make sure that when you have safe working practices in line with health and safety legislation. Now, above that, you have the Human Rights Act, and then above that, you have the European Convention on Human Rights. Now, again, I'm not going to go into this too depth in this video, but let's just say, for example, and by the way, that goes from least important to most important in terms of hierarchy. But let's say we have a bit of non-statutory guidance that's issued here that tells you can't do something. And the most common one that I come across is to do with physical techniques is someone in an organisation says you can't do that. And that's normally based on misinformation or their knowledge or lack of. And they say, for example, I'll give you a prime example. You can't use a technique that may cause pain with any of our service users or patients or residents because it's against the law. But let's say that we need to do it and we have the right under our common law and statute law. And I'll give you an example. Some time ago, I know of someone who was attacked by a patient. They didn't know what to do. They used a particular technique on that patient to ensure their safety. That person was disciplined because it wasn't part of the approved program. They were found guilty of gross misconduct, and they were going to be sacked. And they got a solicitor, and they took this solicitor with them to the tribunal, and the solicitor successfully argued that their client was in fear of their life, and that's why they used the technique they did, and they had the right to do so. And that person won their case. So we can't put up a wall and stop the law coming in, and I've done a video on that. You can go and find that one. But let's say it's also safe in the workplace to do it. So let's say we have a particular service user, patient, member of the public, whoever it is we're dealing with, and they're at more risk of serious injury and death from, say, being restrained in a particular position. And the staff use a technique, maybe a restrictive technique, that might cause discomfort, harm or pain, but it's justified legally because it's preventing a greater harm. So from a health and safety point of view, let's say it's stopping staff and that service user or patient suffering serious injury, potentially death. That, if it would override non-statutory guidance. And if it was preventing death, then it's consistent with Article 2.1 of the Human Rights Act. And Article 2.1 of the Human Rights Act is really important because that is a piece of legislation that says that all public authorities, and these are direct public authorities or quasi-public authorities, and a quasi-public authority is basically a private company doing a public authority job. So a prime example would be a private security company transporting patients, for example. Okay? Article 2.1 of the Human Rights Act said we must promote and preserve the right to life. So let's say a child's going to jump out of a window, they're going to seriously hurt themselves, staff rugby tackle that child, break the child's arm, but they save the child's life. If that guidance said they've caused harm to a child when they couldn't have done, but they acted within the remit of reasonableness under law and within the confines of health and safety in promoting the duty of care to that person, and they save the person's life on the Human Rights Act, that would override that guidance. So I think you get the idea. And then above this you have the European Convention on Human Rights, and this is where it gets really interesting. This is the Human Rights Act, 1998, and if you look at section 6 here, this is law, statute, it says here, acts of public authorities. And under section 6, part 1, it says, it is unlawful for a public authority to act in any way which is incompatible with a convention right. So if Article 2.1 of the Human Rights Act was used to promote and preserve someone's right to life, and someone said that someone couldn't do something that would enable them to do that, then that public authority, be it a direct public authority or a quasi one, so it's a private company acting as a public authority, would be acting incompatibly with the convention right. Now, I mentioned this in one of the videos earlier on. This is Article 13 of the European Convention of Human Rights, and this sits above the Human Rights Act. This is one of the most important pieces of legislation. It says, everyone whose rights and freedoms are as set forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding that the violation has been committed by persons acting in an official capacity. So, just to go back to here, if someone within an organisation was acting in line with their rights under law, common law and an act of parliament, it was consistent with good health and safety practices, consistent with the Human Rights Act, but they were prevented to do so by a piece of non-statutory guidance or local policy or procedure or some advice from someone in local management or a trainer or whoever, then Article 13 of the European Convention of Human Rights kicks in, where they can actually seek an effective remedy for having their rights violated. And this is not only the member of staff, this is also the person who could have been harmed or killed. So obviously their family would come if the person had been killed, who would not have been harmed or killed had this person used a particular technique. And the fact of the matter is all of that above will override that there. So this is something we use. As I said to you before, I'm not a lawyer. This is not an accurate legal representation of the law. It's something I use to help sort of me with my clients put things into the right order to try and keep my clients and people safe. And many times we've had to challenge non-statutory guidance where we've acted with higher legislation with the primary aim of keeping everyone safe. I mean, that's all we've ever wanted to do, is to keep people safe, staff and service users, patients and members of the public. But far too often, as this email has just highlighted once again, people are being told things at the bottom level of this hierarchy and being expected to follow it when it probably breaches a lot of the stuff above it. even though the misinformed person giving that information thinks that it's legally correct to do so. But by doing that, they actually can end up in a hell of a lot of hot water. I hope that helps. I hope that explains things to you. Please leave a comment below, and if you like what you've seen and heard, share it far and wide. I mean, hopefully this will help someone else put things into perspective. But there you go. Enjoy. Speak to you all soon. Thanks ever so much.